becoming a federal magistrate judge, duties, appointment, and discussion. My name is Tara Norgerd, and it's my honor to introduce our speakers and to serve as your moderator tonight. I will begin with the Honorable Chief Judge Toonheim. My guess is that nothing about Chief Judge Toonheim's childhood in Newfoundland, Minnesota, his legal studies at the U of M, his work in private practice, the AG's office, or for Senator Humphrey, his chairing of the Records Review Board on the President John F. Kennedy assassination, his work on countless committees, or even his pivotal leadership of international rule of law projects around the globe gave him the playbook for how to guide the federal court through a global pandemic. But this he has done with extraordinary leadership, dexterity, and success that has ensured that justice was never delayed in this district. He has served our district as judge since 1995 and our chief since 2015. And I'm hoping he has a vacation planned for himself when he steps down from the chief position in July of 2022. After the chief, we will hear from the Honorable Judge Susan Richard Nelson. Judge Nelson was appointed to the United States District Court by President Barack Obama in 2010. Perhaps most apropos to tonight's topic, she served our district as a United States Magistrate Judge from 2000 through 2010. Before joining the bench, Judge Nelson earned a reputation as one of the brightest litigators in the country over her 17-year career with the law firm of Robbins, Kaplan, Miller, and Cerisi. Among many other feats in that time, she served on the trial team representing the state of Minnesota in the famous tobacco case. Judge Nelson has long been a leader in the bar, having served as president of the Minnesota Women Lawyers and for many years on its advisory board. And she has also been active in the Minnesota chapter of the FBA, active to say the least. She recently served as our president. She is a mentor and a role model to many and known for her extraordinary leadership as a judge. With gratitude, respect, and a great deal of admiration for both of them, I am happy to introduce our chief, Judge John Artunheim, who will be followed by Judge Nelson.
Well, thank you very much, Tara. It's great to be introduced by you. It was wonderful. Thank you. Let me get this organized here. Let me move things around today. There we go. Okay. Thank you for the wonderful introduction, and thank you everyone for joining us today. This is an exceptional idea to have a seminar that really focuses in on the job of a federal magistrate judge. Some have said it's one of the best jobs in the federal system. I've never been a magistrate judge, but I've worked very closely with magistrate judges for 26 years now. And I can say that we have had some exceptional magistrate judges here in the District of Minnesota. You're going to hear today from the experts, judges who have served as magistrate judge and can give you the inside scoop on what the job is all about. I'm anticipating at least 2 vacancies, probably in the next 6 to 8 months here in the District of Minnesota. So this seminar is very, very timely. It is an appointment process which is important to understand. It is a very strictly run merit selection process, which is something that I'm particularly proud of. I think we've done a great job in our many years of appointing magistrate judges here in the District of Minnesota to get it right. We'll go through this in more detail, but when the 5 finalists come to the district judges, I know that the district judges take a lot of time to study the backgrounds and the interests of the individuals who are the finalists. And we approach this very, very carefully. You know, every time we are picking a magistrate judge, I hear from someone, well, I'm not going to apply because I think the judges will appoint so-and-so, or the judges will appoint this kind of person. You know, no one can predict what happens in this process. And I think it's folly to do so. If you're interested in the job, you should apply. You might get it. and you might maybe don't get it this time, but you might set the groundwork for getting it the next time. I strongly encourage people, if they have an interest in becoming a federal magistrate judge, even if you feel like you don't have the perfect credentials for the job, you should apply. No one has the perfect credentials for the job. None of us who are district court judges had the perfect credentials for the job that we got at some point in time. I can definitively predict, however, that you won't get the job if you don't apply. So get in there, get in the fray, and I encourage you, and hopefully you'll be inspired by this program today to apply for the job. No one can predict exactly what the outcome will be, and I've been surprised sometimes, but that's okay. We've gotten great magistrate judges over the years through this process, and so I just simply encourage you to take the time to think very carefully about this. Maybe take some time to watch a magistrate judge in action. Our magistrate judges are very happy to allow someone to do a little shadowing to understand the position better. And we're looking for excellence. And we also value diversity in our process as well. So I encourage you, if you are interested, to look further at what the job is all about and to apply if you're interested. So I look forward to the discussion today. I'm going to be part of it the entire time, and we have a panel toward the end, and I'm going to discuss in more detail the appointment process so that you understand that. But with that, I will turn the microphone over to Judge Nelson.
Well, thank you, Chief, and welcome everyone to this wonderful seminar. I had the privilege of serving this district as a United States Magistrate Judge for 10 years, from 2000 to 2010. Simply put, I loved the job. I entered it mid-career, found it to be very re-energizing, and filled with new and exciting challenges. For many years as a civil litigator, I appeared before magistrate judges all over the country. But even then, I did not fully appreciate the breadth of their responsibilities, frankly, until I applied for the position. And so in my experience, even federal practitioners who often appear in federal court, even they may not fully understand the scope and duties of the position. And I hope that this seminar helps everyone understand it better. So in imagining this seminar, the planning committee had a few distinct goals. First, we wanted to provide an opportunity to educate the bar, those who appear in federal court and those who do not, about the duties of a magistrate judge. Second, as the chief said, we want to strongly encourage applications from a broad and diverse group of qualified and interested candidates. And finally, frankly, we want to bring some transparency, not only to the position, but also to the selection process. So I want to take just a few minutes now to turn to the transparency piece and start our conversation today by briefly commenting on what I would describe as some myths or misunderstandings, if you will, about the position in the selection process. The chief commented on a few, and I want to elaborate on that a little bit more and hope that that conversation will then continue with the panel and continue in the breakout rooms. So I want to address 4 issues. First, I want to address the concern that the bench has in mind in advance whom they intend to appoint to a particular opening, and that the process is not inclusive. Second, I want to comment briefly on the independence of a magistrate judge. Third, I want to address a commonly held view, primarily from civil litigators, that magistrate judges spend their days doing nothing but resolving discovery disputes. Finally, I want to comment on a common concern that a lack of civil experience on the one hand or criminal experience on the other would disqualify you from being seriously considered for the position. So first, I want to talk a little bit about what I will generally describe as inclusiveness and fairness in the process. So here I am 21 years later after being appointed a magistrate judge in this district, and I've been a voting member of the district bench for 10 years that appointed many of our current magistrate judges. And I can honestly say it is crystal clear to me that it is merit and excellence, excuse me, above all that matter here. We have very heavy dockets in federal court. We rely heavily on our magistrate judgments to take the laboring oar on managing civil litigation all through discovery and criminal cases until trial. And so the bench encourages and welcomes you to apply and assures you that everyone will be judged strictly on the basis of their abilities to perform the job. Second, I want to address a concern that I've often heard on an ad hoc basis, and that is that magistrate judges aren't somehow independent. Magistrate judges are judges with complete independence. They rule based strictly on their view of the law and the facts. All judges at any level are subject to appeals. All my decisions are subject to appeal to the Eighth Circuit, and the decisions of magistrate judges are subject to appeal to the district court. But that does not diminish the independence of either of those positions. Third, as to discovery disputes, it is certainly true that management of civil litigation is one of the important roles of the magistrate judges. But as you will hear from the panel of magistrate judges you're about to hear from, there's so much more. Mediations, motion practice, all criminal felony pretrial work, suppression hearings, Social Security appeals, habeas cases, civil rights cases brought by prisoners and those civilly committed, misdemeanor court, and on and on. Now, it is also true that most of us in private practice were either civil litigators or criminal litigators, but not both. In my case, honestly, before I seriously thought about applying for the job, I didn't know the difference between an indictment and an arraignment. Magistrate Judge Menendez was primarily if not exclusively, a criminal lawyer. And so here are two examples of folks who clearly had more experience on one side of the equation than not, who were appointed to the bench. We understand that as the bench. We don't really expect you to have a broad swath of experience in both camps. We look to your resourcefulness. Are you proactive in filling that gap? Your dedication in getting up to speed. I'm sort of reminded of Judge Dougherty, who was here, who, when he applied, went to great lengths to learn about patent law and attend different hearings so that he would fill that gap. And that's what we expect of applicants for the position, but we don't expect you to come to the table with all of that experience. So I just wanted to provoke some thinking and start the discussion on these issues. But now it's my pleasure to introduce our moderator, Tara Norgerd. As many of you know, Tara Norgerd's practice focuses on intellectual property and high stakes business litigation at the Carlson Caspers firm. She has served as general counsel for the receiver in a massive Ponzi scheme and has served in that capacity in other such litigation. She clerked for the Honorable Judge Lay on the Eighth Circuit, serves as the lead on diversity and inclusion initiatives for FBA nationally, has chaired and served on the merit selection panels for the magistrate judges in this district on many occasions, and is well known to all of us. So she's in a unique position to moderate this discussion, and so I want to thank Tara in advance for her willingness to do so. Thank you, Tara.
Thank you, Judge. It is an absolute pleasure and my honor to do so. Apropos to what Judge Nelson was just talking about, I think an introduction of our panelists will be illuminating in its own right to everybody here on the call, because there are lots of varied backgrounds, different paths that each of our panelists who are magistrate judges have taken to the bench. I will begin with the Honorable Judge Leo Brisboy, who was appointed to our magistrate bench in 2010. He earned his undergraduate degree magna cum laude from Hamline University and his JD from the Mitchell Hamline School of Law. He served as a criminal prosecutor with the Judge Advocate General's Corps for the United States Army in Europe, and as a clerk for the Minnesota State Intermediate Court of Appeals. Before his appointment to the bench, he was a partner with the Minneapolis firm of Stitch, Angle, Kreider, Dodge, and Unke, and he also served as president of the Minnesota State Bar Association the year before he was appointed to the bench. Judge Brisboy is a citizen and enrolled member of the Ojibwe tribe of the White Earth Reservation. He grew up in Hibbing, Minnesota. We'll also hear from the Honorable Judge Kate Menendez, who became a magistrate in 2016. And as most of us know, was recently nominated by President Biden to become a district judge here in Minnesota. Prior to joining the bench, Judge Menendez worked in the Office of the Federal Defender for more than 18 years, where her tenure included 2 very notable appearances at the United States Supreme Court. Judge Menendez is a graduate of the University of Chicago and NYU School of Law, and she clerked for Judge Sam Irving III on the 4th Circuit Court of Appeals. We'll also hear from the Honorable Judge Dougherty, the newest member of our magistrate bench, having been appointed in 2021. Prior to joining the federal judiciary, he served as investigative counsel to the U.S. Senate Special Committee on Aging, worked in the Minnesota State AG's office, and served as an assistant United States attorney here in the District of Minnesota. His undergraduate career was split between the University of Chicago and the University of Minnesota. And he apparently came to like Minnesota so much, he stayed here for law school and graduated as among the class of 1986. We also have on our panel Catherine Rowe, who is our federal defender and who has served as our federal defender since 2006. She was appointed to this role after serving as a district court judge in Hennepin County from 2002 to 2006, and as an assistant federal defender from 1989 to 2002. Catherine attended Georgetown University Law Center and Union University and Albany Law School. And Ms. Rowe has served on many merit selection committees in the District of Minnesota. And last and certainly not least, on our panel, we have Anders Folk, who is now senior counsel to the Deputy Attorney General of the United States. Prior to that, he served as acting United States Attorney and first assistant United States Attorney here in the District of Minnesota. He practiced law as a partner in the Stinson firm, and he served as assistant U.S. Attorney and a Marine Corps judge advocate. He attended the University of Minnesota for both his undergraduate and his law school degrees. So with that distinguished panel, Judge Brisboy, I'd like to give you the first opportunity to speak generally on what is a magistrate judge in the United States. What are the nuts and bolts and the basics of that position?
Well, the nuts and bolts we're gonna get into in more detail with the rest of the panel members, but let me first echo something that Judge Nelson said in her remarks, that a United States magistrate judge is a judge. I can't tell you how many times I have lawyers, kind of either ask outright or imply, well, when do we get to see the judge? And I said, well, you're already looking at him. Yeah. And the statutes provide that specifically. I mean, in 2018, the Magistrate Judges Act, which was passed in 1968, was 50 years old. And so there's been the magistrate judges system for over 50 years now. And the workload of the federal district courts has only expanded almost exponentially. And I think Judge Nelson and Chief Judge Toonheim can correct me if I'm wrong, but the number of district judges in the nation has only minimally increased since the late 1980s and has not kept pace with the workload. And I think that's what led Justice Sonia Sotomayor to say, quote, without the distinguished service of these judicial colleagues in referencing the magistrate judges system, the work of the federal courts would grind nearly to a halt. If Judge Nelson and Chief Judge Toonheim had to do all of the judicial duties that the magistrate judges bench does, there would be no trials. And we all know how time consuming the current trial calendar is. So that it just points out the essential aspect of what is a United States magistrate judge. They're a full judicial officer. The process for appointment is 28 United States Code Section 631. The duties can be as all expansive and as encompassing as they are here in the District of Minnesota. That authority and discretion is given to the district bench under 28 United States Code Section 636. And just to kind of close the loop on how I started this, when a magistrate judge takes office, the chief judge will swear them in and will use the same oath that the justices and district judges take under 28 United States Code Section 453. So we're going to move on now and get into the more specific questions, but I think anybody who's interested in this position should understand the solemnity and the responsibility that goes with it. And so United States Magistrate Judge, emphasis on the judge is key.
Thank you, Judge Brisboy. So let's turn now to more of the specifics on what a United States Magistrate Judge is here in the District of Minnesota. And we decided to mix it up a little bit because Judge Menendez, as we heard, comes from a criminal law background as in the Federal Defender's Office. But Judge, I trust that you've learned a fair bit about civil cases since you have joined the bench. Can you talk to us a little bit about main duties in civil cases for a magistrate?
Of course. It is no overstatement to say that I knew absolutely nothing about civil litigation when I took the bench. I didn't even understand whether an interrogatory was a single question or whether the word interrogatory described the whole set of questions. And that's just one of the many things that I didn't understand. I've been on the magistrate judge bench for almost 6 years. It is a wonderful job. And one of the reasons I love it so much is because I had to learn so much new information before I could do it effectively. Not just the mechanics of civil litigation, but the mechanics of so many subtypes of civil litigation, like patent law, for instance, and social security law. Our job starts with the very beginning of a case at the pretrial conference or sometimes even sooner. And magistrate judges are responsible for setting schedules, for handling discovery disputes. But in our district, we have an additional responsibility, which is really actively managing cases toward settlement. Magistrate judges hold early settlement conferences in the vast majority of cases in our district, unless they settle on their own without our intervention. And I frequently hold status conferences and check-in opportunities with lawyers to make sure that the cases are proceeding smoothly, but also that the lawyers are talking about settlement throughout the case. That's one of the ways that we help manage the enormous docket so that the number of cases that go to the district court for dispositive motions and trial is something that we could begin to actually handle. Plenty of substantive legal issues arise during those discovery disputes and disputes at various stages in the case. It is never a week goes by that I don't have something new to research or new to dive into. I have to say, I echo what Judge Nelson said. My background was entirely in criminal law. And while I felt pretty comfortable with the criminal side of the magistrate judge duties, I knew that I would have to work really hard to understand the civil side of the magistrate judge duties. And those make up the vast majority of how I spend my time. But it was easy to get up to speed because my colleagues were so welcoming and offering of help at any turn. If I had a silly question like, what's an interrogatory? I picked up the phone, I called my much more civilly experienced colleagues, and I was immediately pointed in the right direction. So I just echo, don't assume you're not qualified because you've only done one of the many duties you're going to hear about tonight. Assume that you could be a great magistrate judge if you love to learn and if you're willing to put in the work.
Thank you, Judge Menendez. Civil cases are obviously a large part of the caseload for a magistrate bench, but also we have a lot of criminal duties for our magistrate judges. And Judge Dougherty, would you tell us a little bit about those here in the district?
Sure. So unlike Judge Menendez, she was talking about how she had to transition from criminal to civil. I've been a criminal lawyer just as she was for quite a long time. And so really it falls into a couple of, I'll call them buckets. Number one is certain criminal cases, a certain number will just be randomly assigned to a district judge and a magistrate judge. And the magistrate judge on that case, that is basically their case right up to the eve of trial, I would say, when motions in limine get filed. But before that, you'll do the arraignment where people are formally charged. You'll handle pretrial suppression motions, at least on a report and recommendation basis. My confession was no good because I didn't get Miranda. The search was no good because the warrant was defective. And some of this can be very, especially in the developing field of cybercrime and search and seizure in cybercrime, you can get into some very sophisticated, cutting edge Fourth Amendment topics very, very quickly. And that's really interesting and really exciting. Over and above having a case that you basically are the judge on up until it gets tried, there's also criminal duty. And that's where you are agents or assistant U.S. attorneys come to see you. Will you sign this warrant? Will you sign this complaint? Will you sign this trap and trace order? And also initial appearances by defendants who are arrested, whether it's for a crime or for alleged violations of their conditions of release. It's really quite a mixed bag on criminal duty because you often don't know what's coming through the door until a couple of hours before it arrives. So you're really on your toes. But I would say to those of you who don't have criminal experience out there, don't let that deter you because there are people, we've got excellent criminal experience. We're happy to help. And the lawyers on both sides in the criminal cases are also happy to brief these issues up and tee them up for you to make a decision. But it's for someone who likes criminal law like me, it's an absolutely fantastic job and I love it.
Thank you, Judge Dougherty. Judge Brisboy, any other types of cases that you want to provide an overview of? So we have kind of the full picture.
Sure. Before I do that, I want to just comment on one thing that Judge Dougherty said about the criminal duties. And this is because it's an example of how important the decisions we make as magistrate judges can be. One of the things that we do in our criminal caseload is we decide detention hearings, whether someone should be released or detained pending trial. And so that is a liberty issue, whether someone's going to lose that liberty interest. And keep in mind that we make that decision when they're still subject and benefiting by the presumption of innocence. So in some ways, the decision whether to detain pending trial or not can have significantly traumatic impacts on the defendant and their family, because while they're waiting trial, They could be looking at losing their employment. They could be looking at losing their home. They're looking at separations from children, and ultimately maybe they're found not guilty. So those are very important and impactful decisions in the criminal area that we make pretrial, not just the suppression and evidentiary issues, but they're just as impactful as some of the decisions that we make in the civil area. Some of there's been some discussion about how varied this job is, and that's the question that you asked. I mean, the magistrate judges will hear and decide Social Security appeals from the Social Security system, sometimes on order, and then by consent of the parties, and then the review, if there is one, goes directly to the 8th Circuit. Sometimes it's on report and recommendation and then goes to the district judge before it goes to the 8th Circuit. But that is another area where the magistrate judges, if they weren't doing those decisions in the first get-go, the district judges would be severely hampered in addressing the criminal calendar and the civil trial calendar. Habeas corpus petitions. I mean, people hear a lot about that in real crime TV shows and things, but we get them as the magistrate judge's bench. We get them from the state courts where they bring up issues of federal constitutional violations. We can also hear them from federal courts where they're talking about conditions of release, whether they're being detained longer than they should be here in the District of Minnesota. And if they're talking about original habeas problem in the district of conviction, as long as that district is Minnesota, then we can assist the district judges by reviewing those matters in first instance and making reports and recommendations. We also handle Judge Dougherty referenced and Judge Nelson referenced misdemeanor trials. Those are petty misdemeanor trials. You have a regular docket out of the federal forests, the tickets and things that the game wardens put out. And often those people represent themselves pro se, and they ask for trial. Those trials are conducted by the magistrate judges. We handle a lot of pro se cases, pro se litigants in civil context. We get prisoner civil right cases out of the state and federal prisons here. We get a lot of actually, that one thing is I'm constantly surprised by what we do because something new comes through all the time. So it's impossible to give you an exhaustive list. But one thing I do want to mention as in terms of the additional responsibilities of the magistrate judge's bench before I end here, and I see this as a untapped resource available to attorneys who represent clients in the civil context, is that the magistrate judges can conduct jury trials, bench trials to conclusion in civil context upon consent of the parties. And then post-trial, their review goes directly to the 8th Circuit and not through the district bench. That can speed up resolution if you have a case that you think is amenable to a quick resolution. It also can cut down on costs, and it's a resource that I think the litigants don't take advantage of enough. And it can speed up resolution because then all pretrial motions are handled at the magistrate judge's level, and then we don't have back and forth with post interlocutory review with the district bench. So if it's a jury trial, you get the same jury veneer, the same jury you would have gotten with the district bench. It's just that the magistrate judges can give you a date certain jury trial much sooner than the district judge, because we don't have the felony trial calendars that only the district judges can handle by constitutional mandate. So those are just some of the additional things you can be challenged with as a magistrate judge. all of which are stimulating, important, impactful, and very meaningful work.
Thank you, Judge Brisboy. I want to pick up on something that Judge Nelson touched on in her remarks, which is the independence of federal magistrates in our district. Judge Menendez, could you speak to the relationship between the magistrate judges and the district court judges here in Minnesota?
Certainly. When I've attended trainings for magistrate judges around the country, I've been struck by how different districts use their magistrate judges very, very differently. In some districts, you're essentially put on the wheel and you do almost all of the same things that the district judges do, with certain exceptions. In other districts, the relationship is much more dismissive, frankly, and almost one of treating magistrate judges like the law clerks of the district court. I think our bench has a perfect balance. The respect and appreciation that I have always felt from our district court bench is, knows no bounds. I feel very independent to make my own decisions at every turn, particularly for any substantive legal issues. There's no expectation. In fact, it wouldn't be appropriate to reach out to the district judge and say, what do you think about this privilege issue? Or what do you think about this motion to suppress? It's our job to decide those things in the first instance. And then it's the district court's job to review those if they're challenged or appealed. One place we work a little more collaboratively together is brainstorming case management, particularly in difficult or unusual cases. It's my job to herd the cats until the case is ready for a dispositive motion, but I often will reach out to the district judge on the case, particularly in a messy or complicated or uniquely contentious case, and we'll brainstorm if there might be better ways to get things back on track, or how to collaboratively work together during a pending motion to dismiss to also encourage settlement talks. So I would call it a very collegial and collaborative relationship with the district court bench. It does not feel hierarchical or usurious like some of the criticism I've heard from other districts. I think it's a wonderful working relationship. There's also incredible collegiality among the magistrate judges. We are a very tight-knit bench and very mutually supportive. And if any of us runs into a problem, a health issue, a challenge, I feel that we all just step up and really take care of each other. And it's been that way from day one. So I would say one of the best things about the job is the relationship both with the district court and with my fellow magistrate judges.
Thank you. We have a number of topics to get to, and I think we'll leave some of them for the breakout rooms. But what I'd like to turn to Catherine and Anders next for their input. They're practitioners in our federal court. And I'd like to open up the floor to them to talk about what are some of the most important or helpful traits in a magistrate judge from your roles that you've served. Catherine, do you want to kick us off? Oops, I think you need unmute.
All right, some of the basic ones are the same no matter what. They're that a willingness to learn the subject matter, intelligence, excellence, the same kind of things. But in the criminal side, I think that it's really important that the magistrate judge is willing to be patient and understanding and respectful, because on the criminal side, the criminal defendant sees that judge as the judge in their case early on, only the judge in their case. They don't really see other folks until they decide whether to go to trial or enter a plea. And if they feel like the process isn't fair, and obviously the judge is the one who's kind of that representative during the early stages, if they feel the process isn't fair, then it's much harder for them to think about entering into some kind of settlement on the case and allowing a judge, even though it won't be the same one, to have some kind of role in their life as far as sentencing them. So for us, on our side of the equation, it's really important that a magistrate judge realize their role in the process. And the role in the process is you are the person who represents the court early on. You're the only one. And if the defendant feels like they're not taking the time, they're not making the effort, they're not respectful, that is makes a big difference in how they're willing to resolve or whether they're willing to resolve the case.
Yeah, and I would echo all of Catherine's comments. I would also say both on the criminal and civil side, the magistrates are so essential to our practice. And coming from a U.S. Attorney's Office perspective, we're certainly litigating in front of magistrate judges all the time in that kind of initial appearance detention hearing context, and those can be at times very heavily litigated and very contentious hearings. And so I think for a magistrate judge to be able to approach that kind of hearing, obviously with an open mind, be decisive, be insightful, ask questions to really push the government and the defense to really explain why it is in the case of the U.S. Attorney's Office, they're seeking to detain somebody without any opportunity to be released pre-trial, and what is it about this person that makes them a danger to the community or a risk of non-appearance. And to the defense asking the same questions. And so I think as a prosecutor, what you hope for is somebody, again, who can make decisions, who can be analytical and open-minded, and at the same time really provide that kind of forum over and over again, because we will have situations, and Catherine and her office are part of these like we are, where some days we'll have 10 plus defendants. And so you'll kind of have a kind of a repetitive nature to these hearings, but they're really important. And each one of those defendants is an individual, and to each of those defendants, the most important hearing they may ever have, at least for their kind of initial appearance in court. On the suppression front or the motion hearing front, Judge Dougherty referred to this earlier, but the suppression hearings we have in the District of Minnesota are at times incredibly heavily litigated. And again, I think, the great magistrate judges are the ones who can kind of get the parties to cut right to the issues at hand, make sure that we have a good record developed that really brings out all the nuance that may be required for the judge to rule on that particular issue. And at the same time, obviously, I would always say, have patience for litigants who litigators who are oftentimes dealing with sometimes knotty issues where maybe the law is really well developed, but maybe it's not. And so I think all of those traits, again, are what we hope for in all of our judges, whether they're state court, federal judges, Article III, circuit judges, whatever. But I think with the magistrates, it's especially important because our magistrate judges get a volume of cases and a volume of litigation that I think is really something else, and requires a lot of kind of the ability to repeat those traits on a very frequent basis.
And I'll just chime in here as the civil litigator to round out this discussion. And frankly, the traits that both Catherine and Anders spoke to are equally important in civil litigation. And I assume there are many civil litigators on the line here tonight. But I think it's really important to recognize that civil litigation encompasses really quite a broad range of practice areas, and many of which are legally and factually quite complex. For example, I am a patent litigator, and we, as you may know, have a very high level of volume of patent cases in this district. And as patent litigators, it's our job to explain the technology and the issues to the court in a way that makes sense, but is extremely helpful when a magistrate judge in particular, who takes the case at that first pass and is with us until for most of the pendency of the case. But when the magistrate takes the time to engage with us and understand what our case is about, that really makes all the difference in the world, not only for discovery disputes and settlement, but just in how the parties operate, frankly, when we're not before the court. When we know that our judge is engaged, things run very smoothly. And so from where I sit, I think a strong judge, and the strongest judges have asked questions, and they acknowledge when something is new or unknown, or is new legal territory. That helps us, the litigators, calibrate what we're presenting, our arguments and our facts, our technology, whatever it may be, helps us calibrate it in a way that will be most helpful, we hope, for you. Again, I think it goes back to that engagement. I heard the word patience, and that oftentimes needs to come to bear in our patent cases in particular, which can be long and tedious and complex. And frankly, just a sense of humanity, because we're all in the courtroom in this together, and magistrates and judges who understand that we're all here doing a job, I think makes everything run more smoothly and frankly, to the best result.
Tara, if I may, your comments just made me think of a situation I can think back on from my time in private practice that I think again illustrates one of the traits we look for in a magistrate judge, which is I can remember being in day-long settlement conferences with a magistrate judge who would be taking breaks in the middle of a very contentious attempt to settle a case to go out and then cover first appearances, and then to come back in and work with the parties towards settlement, and then go back out and cover a motion hearing. And that kind of pivoting and giving all the parties to all this different litigation that's going on simultaneously, that judge's total focus and attention, and making those parties kind of the most important matter in front of them, while these things all may be more or less happening simultaneously, I think illustrates this need for our judges to really be able to, I don't know if you want to call it thinking on your feet, but being able to really multitask, but in a way where you maintain both high IQ but high EQ, because you're dealing with all these different parties who are often so differently situated, and to be able to kind of do it in a way that I think is kind of seamless, and that's again a trait I think we look for in magistrate judges.
Well, and I would say for anybody who's thinking about applying for this job, there are outstanding role models on our magistrate bench, both now and in history, that have exactly those qualities, Anders, that you just spoke about, and Catherine, and kind of all of our ideal qualities when lawyers come to the court really have been embodied in spades by our magistrate judges, and we're very fortunate in Minnesota to have that. And I think Judge Menendez perhaps described it best. I'm assuming that when you come to this role, you're joined in hands with others who've been traveling this path before. And so, it's not as though you have to come to the role ready to pivot and, decipher all sorts of new laws and technology. You've got people with you to help you do that, both your colleagues on the bench, as well as the lawyers who really, truly do want to help you do your job. So we want to make sure to have plenty of time left for the breakout session. So I'm going to kind of zoom ahead in our schedule here and return to the chief to please, if he would, be kind enough to tell us about the application and the selection process for magistrate judges in District of Minnesota.
I'd be happy to, Tara. The process is rather long and involved, and there's some initial work that we have to do in order to get the permission of a National Judicial Conference Committee to fill the spot. They kind of control the number of magistrate judges in the country, and there are pushbacks from the Budget Committee too, which affect how they approve magistrate judge replacement decisions and additional magistrate judges. But once we have the go-ahead, when we have a vacancy or a vacancy that is certain to occur, we have to get approval from the circuit to fill the position, and then the go-ahead from the Administrative Office of the United States Courts, and then the approval of the Magistrate Judge Committee, the Committee on the Magistrate Judge System. Once that's done, then we notice the vacancy. As judges, we work together to appoint a merit selection committee. We've done a different selection committee each time, although frequently people serve on multiple committees over time because they have experience. I like to have some experienced members of the committee and newcomers as well to give us a fresh perspective on the choices available. There is a period of time in which the individuals interested can apply. We usually keep it open for about 3 weeks or so people have plenty of time to consider it and to fill out the forms. There, as part of the process, you have to agree to release of taxes, records, attorney discipline, all those kinds of things. There are letters of reference that are sought. And the Merit Selection Committee goes to work. It's not an easy task for the committee. They have to sift through many applications. And typically the first go around is a decision of who to interview. Now, I think in most cases, the committee has interviewed at least 10 applicants, sometimes as many as 15. It is up to the committee to decide how many they wish to interview. Interviews were done over Zoom last time, but in the past, interviews have been in person. And then the committee gets down to the hard work of deciding who are the 5 finalists to submit to the district court. Sometimes there's even a second round of interviews before the final 5 are chosen. And then that moves on to the district court. Judges do some examination of all the materials that are submitted. We're very careful about that. Most of our district court judges will spend a lot of time going through all the written materials. There's always a few judges who are busy, say they're in the middle of a long trial or something, and they may not have a chance to review all the materials in great detail. But the interviews are important. We set up an interview for each of the 5 at the same time. The judges ask questions. I'm thinking about adding the magistrate judges to that process this time to just participate in the interviews. But only the district judges can meet to make the final decision on who should be the next magistrate judge. Senior judges fully participate in that. That is required by statute. Some districts weren't permitting senior judges to participate. I think with the wealth of experience that our senior judges have, it's a good idea to have them participating in the selection process. And we decide that day. After we finish the interviews, we have a discussion, and sometimes it takes us quite a while. Sometimes it's more quick, but we make the decision that day. We then call the successful applicant and say, you're not appointed yet. You have to complete and survive an FBI background check. Which is typical of all the background checks the FBI does. It takes a while. They do a fairly in-depth background check, which is, of course, required for a position of this importance. We do not announce the person who will become a magistrate judge until the FBI has submitted the results of its background check and the person has been approved. Then we make the announcement and we go ahead and we swear the person in as soon as they're ready to begin work. And that is a process that typically will take about maybe 4 to 6 months to complete, depending on how busy the FBI is with their background check. But I want to just point out the value of the Merit Selection Committee. We try to make it a committee that has representatives of all different types of practice, a committee that's diverse in many respects, but plus a committee that has some experience on it too. It's been very interesting to watch the committees over the years. I've been involved in the selection of magistrate judges for 26 years now, and our committees have done just outstanding work, and we really appreciate that service to the court. So Tara, that's a brief outline of the process.
Thank you. Chief, can you talk just a bit about what the selection criteria are? We talked a little bit about traits, but there are also some other criteria that I assume are looked for in a magistrate application.
Yeah, there's some statutory criteria. You have to be in good standing for 5 years as a practicing attorney, which all applicants can easily satisfy. But I think what the judges are looking for, and you can see what the statute says that we should look for. It's 28 USC section 638. But what are we looking for? I mean, ultimately, it's someone who we believe will be an excellent judge and is ready to be an excellent judge based on their background and experience. We want individuals who are hardworking because there's a lot of work to be done as a magistrate judge. We want someone who will work well with their staff, with other magistrate judges, and with district judges. We're looking for strong legal skills, obviously very important to all of us. Individuals who have shown excellence in their legal career, and probably most important at the end is a judicial temperament, the right kind of demeanor to be a judge, who will listen carefully, take into account all viewpoints, and issue a reasoned decision. The kind of experience that the individual has had in their past is less important. You've heard our magistrate judges today talk about areas where they had no experience whatsoever. Experience in all areas is always helpful, but you don't have to be experienced in criminal law. You don't have to be experienced in civil litigation. What you have to have is excellence in a career. And I think it's important to interview well. I think that's important for any job, and anyone would recognize that. As I said, judges go through the materials carefully. Some may have an opportunity only to scan materials because of the busyness of their schedule, and therefore interviews are very important. So I think also being involved in community activities and other types of experience in the past is also helpful. Law clerk experience is helpful in some respects, but certainly not necessary. So that's a quick overview, but you can look at what the statute requires us to look at as well. And certainly, last but surely not least, we are interested in diversity, as we should be in all of our positions.
I think I'm back on. Thank you very much, Chief Judge Toonheim.
Sure.
Appreciate that. We wanted, again, to make sure that there's plenty of time for discussion in the breakout rooms, which we're at about 5:27 now. So I think we'll transition to those where we can address, hopefully, some of the other topics that we had slated for our discussion here today. We can do it in smaller groups. And each of the breakout rooms will be hosted by one of our magistrate judges and maybe even one of our Article 3 judges. And then we'll come back for a brief close after the breakout session has concluded. Before I do that, if we could just put up the slide, I'd like to just thank briefly the planning committee who put this together, this presentation together. It was really Judge Nelson and Judge Toonheim's vision made possible by the folks that you see on this screen and others, and our fearless leader, Katie Barrett-Wick. And also with gratitude to Judge Thorson. Our next slide is going to be a dense slide, but you'll see it available on the Minnesota chapter of the FBA's website. This is a library of written materials that Judge Thorson curated about what is it like to be a magistrate judge? What is the history of the position? What are tips and other things in both video and written form? And finally, the code of conduct and a recent application for the magistrate position. So you'll be able to find that on the Minnesota chapter of the FBA's website after this program. And again, with thanks to Judge Thorson for her work putting that together. So now, by the magic of Zoom, somebody behind the curtain will populate us all into discussion rooms, and we'll come back at the end. I hope that everybody enjoyed the time that we all had together in the breakout rooms to be engaged with each other on a bit of a more personal level. Our time together has come to a close, but I'd like to again thank our Chief Judge, John Toonheim, thank Judge Susan Richard Nelson for their vision and the generosity of their time in putting this together. And I
can pick up. I know Tara was having some technical problems, but nice to see everybody. I'm Katie Bearwick at the Best and Flanagan firm. I just want to thank all of our judges, our magistrate judges, all met in team and did a lot of planning for this event, which was really, really thoughtful. And we appreciate you making time in all your busy schedules. So all the judges, to Catherine and Anders, thank you for presenting, and to Allie Mertens, my colleague here at Best and Flanagan, who's been a bit of a Zoom guru for us to help us through. So thank you for joining. And I will just one more time, I will paste the materials into the chat. And yeah, we hope that you will continue to engage on this topic and to encourage others to look at the materials as well. So thank you, everyone. Have a good night.
Thank you.
Thank you.